May I make an unlisted mentioning your lordship?
No.
Lord, counter affidavit has been filed by the state and the report has been submitted.
In the report, we have 5 minutes.
Yes.
At 8:36 minutes, we have come to a conclusion that there was a call which was made.
Huh?
There was a call which was made during that period of time. But what is the content of the call? What was that we are unaware of? That call during that particular period was made. If minutes have page 36 minutes,
He is already convicted. Whether this call was made between main accused and him or not, that will be decided by the appellate court.
Lord, these accused came from Bihar, my lord, and they committed the murder of the deceased near his home, deceased home.
You see,
They fled in the same. They fled away in the same vehicle. There was an overt act of these respondents. They have participated. They have attacked the deceased with the lathi and rod. They have confirmed whether the deceased is dead or not, and it is confirmed by the postmortem report also, my lord, because it corroborates that there was an injury by the hard and blunt substances on the head of the deceased, and the eyewitnesses.
What is that report? Yes, state.
Yes, minutes. We have put that minutes at page 36 minutes, which my lords have. Is our counter affidavit by respondent number 1 state. The page 36 starts minutes. And minutes, it somewhere in the middle minutes during the investigation, when Rajveer Singh of the first party was contacted, he told that on 5/7/2025 at about 17:15, he received a threatening call on his mobile number such and such from mobile number such and such, in which Ranveer Singh, son of the resident of Sajid, threatened him. On being questioned about the recording related to the incident, he said that he does not have any recording. During the questioning, the applicant told that he has never met the person who gave the threat. Ranveer Singh, after he came out of the jail, nor has he ever received any other call before this call. In this regard, the second party mobile number such and such was contacted and questioned. During the interrogation, he stated that while he was in divisional jail, a WhatsApp message was received on his family mobile number and he was abused. To verify this, his son Ranveer called him on such and such minutes, and no abuse or threat was exchanged between the two during this call. He stated that
This 716 number is of this Ranveer Singh.
Of his father.
Mobile number 5716
of respondent number 2, my lord, his father, Narayan Singh.
But the call was made by Ranveer Singh.
Yes, my lord.
Ranveer Singh.
Yes, my lord. He identified himself as Ranveer Singh.
Yes. Who appears for this?
I'm appearing for R2 and R3.
Yes. Why
this-
did you make a call?
In fact, that when I was in jail, this person, Rajveer Singh himself, who is a lawyer, I am appearing here also, as if he is a complainant also, but he is appearing himself. And he had made a call to my family, and which
there is no report after the call has been made, no WhatsApp message, no proof have been submitted by the respondent that I have called or given any WhatsApp message. If I might have done, they must have reported or they must have submitted to the IO that I have given some WhatsApp message or call, but there is nothing on the record. There is nothing on the record to show that I have called them or I have sent a WhatsApp message.
My lord, this petitioner himself has 3 criminal cases against him. He himself, and he filed an SLP against the main accused, which was dismissed. And in the similar,
Lord, how it is related to that which criminal
because main accused is in the same
these
case.
respondents came to my home. They attacked my brother. My brother got dead over the.
But there is no recording.
I was also injured.
There is no recording. They
came from Bihar. They came from Bihar in the same vehicle. There is no overt act. They have attacked the deceased as informant. It's a lathi and rod.
They allegedly came by the same vehicle, but they were
Where
not
is that?
arrested.
Where is that order of Amar Singh? SLP of Amar Singh? Have you filed it? Is it on record?
Milord, Milord,
Yes, Mr. Counsel.
Yes. Yeah, I have filed a complaint which has, with
Which is that order in which we have dismissed the SLP of the present petitioner against bail granted to Amar Singh.
SLP number is 14115 of 2025. The main accused Amar Singh, who is alleged to have fired from the rifle and by which bullet the deceased is said to have been has died. But I have been said that R2 and
You, everything you will argue orally.
yeah.
Milord, Amar Singh bail has been already granted.
You practice here regularly or you come from outside?
I am here only.
You don't understand what we are asking. You are arguing that the SLP of Amar Singh is dismissed. Where is that order? You are arguing orally. We will dismiss your bail, reject your bail.
So that I understand, my lord. What I am saying is,
Then you should understand. Upon hearing the counsel for the parties, we are satisfied that the bail granted to respondent number 2 and 3 deserves to be set aside. Accordingly, the impugned order is set aside. Happy?
no, I am not happy. I'm not happy. Because
But we are also not happy.
so in the High Court, it is all these aspects have been considered. That is why the bail has been granted.
Where is that order? That is what we are asking.
We'll seize this.
High Court order.
We'll seize your I-Pac.
But it is the.
What is this?
Lordship, this is your.
You are arguing on the basis of some document which is not on record, and repeatedly we are asking for it. And both of you don't understand how to argue a matter.
Lordship's your lordship's order is here.
Yes, sorry, dismissed, yes.
Your
Yeah, it is set aside, the impugned order is set aside. It is also brought to our notice that the respondent number 2 and 3, who are father and son, they can account who is father, who is son.
Respondent number 2 is father.
Respondent number 2,
Who is father?
it is also brought to our notice that from the mobile number of respondent number 2, comma, his son,
Let's. I
respondent
apologize, we will file it.
his son, respondent number 3, has made a threatening call to the petitioner after his release on bail under the impugned order passed by the High Court. Full stop. In view of the above, we are satisfied that the respondent number 2 and 3 have not conducted themselves properly, and therefore they do not deserve to remain outside the jail, because there is apprehension that while on bail, they may further threaten the petitioner and may put their life in jeopardy. Accordingly, the SLP is, the appeal is allowed, and the bail granted to respondent number 2 and 3 is set aside. Yes.
Grateful, my lord.
My apologies.
So-
Great.
In item 2, Lord, a reply has been filed by the
Yes.
complainant. Lordship,
Leave done.
I appeal for the complainants, Lord.
Yes.
Lord, in
Lord, your Lordship will see, your Lordship already 1st of December 25.
Yes.
So they procured the interim protection by making a statement that we are ready to execute the sale deed
Yes,
on
yes.
30th of March. Please see
That
1st
is
of
what-
December order. And Lord, now they don't turn up. I give them a notice, they don't turn up for sale deed. This is the whole ground. Please see 1st of December order, Lord. That is the only pretext on which they sought interim protection. Please see 1st of December order. Para 2. London Senior Counsel for the petitioner submits that under the agreement to sell executed between the parties, time allowed for execution of sale deed is till 30th of March 26, and the petitioner is still ready and willing to execute the sale deed. On this basis, they secured interim protection, Lord. Now please see my application, Lord. On 16th of March, I sent them a notice that please come for sale deed. They don't come. I kept waiting from 9 in the morning till 5 in the evening. They do not come. Please see my IM, Lord. 123976.
I think I have a right to open the argument first before the complaint here. Lord, we are still saying that as per the agreement, we are ready to execute.
1 week, 1 week time,
No, just one thing. Page
1
18,
week time.
Lord, page 18, just they have served with a legal notice a document which was not in my possession. Now they have placed it on record without translation.
No, we do not know. Forget about the past.
Lord, my
You executed in 1 week or
Yes,
15
Lord.
days.
Lord, for that, as Lord may say that as per the agreement, they are putting up an unsigned, a receipt for 97 lakh that they have paid me 97 lakh rupees after the agreement to sell. That document, just for a minute, may have a look. Page 18, Lord. Just for a minute.
No, as per agreement. As per agreement.
Yes, Lord, as per agreement, I am not.
Yes,
Now,
he is ready as per agreement.
yes, let him say.
Yes, Mister.
This is over and above the agreement, 97 lakh in cash. Without my
Lord,
signature.
He has signed. The receipts are there. He has signed those.
Lord, this is what I want to show, page 18, Lord. The reply, just for a moment, I can put
It
the
will be in terms of the agreement.
Yes, Lord.
Otherwise, you file a suit for state performance, where the parties will be
And
at
my
liberty to prove
co-sharers-
their respective case.
And there are 6 co-sharers. 5 of them have been granted anticipatory bail by the High Court, Lord. Considering this fact, Lordship, we just have page 18. How this fake receipt has been prepared.
The
Lord.
dispute between the parties arise out of a sale agreement, which, according to the complainant, has not been honored by the petitioner accused. Full stop. Para. By order dated 1/12/2025, we have granted interim protection to the petitioner. Full stop. When the matter was argued today, learned counsel for the second respondent, complainant, submitted that on 15th March 2026, he was present in the office of sub-registrar after informing the petitioner for execution of the sale deed. However, he did not appear before the office of registrar. Full stop. Countering this submission, the counsel for the petitioner submitted that the second respondent is demanding an amount more than.
No, he says that an amount of 97 has been paid to me over and above the agreement to sell. And that should be
That
adjusted.
second respondent is claiming that he has paid an amount of rupees 97 lakhs to the petitioner
Over and above 35 lakhs earnest money shown in the agreement to sell.
over and above the earnest money of
35 lakhs.
35 lakhs shown in the agreement.
Yes, Lord.
I'm disputing that.
Post op. There appears to be a dispute as to the payment of amount at the time of execution of the agreement. Post op. Be that as it may, the dispute between the parties can only be solved in a properly constituted suit and not in this bail petition. Full stop. At present, we are satisfied that considering the dispute, the nature of dispute between the parties, the petitioner deserves to be released on anticipatory bail. Accordingly, so and so, the SLP is disposed of, directing that the petitioner shall be released on anticipatory bail in crime number so and so.
And your Lordship may add that, Lord, he will execute the sale deed in 1 week, Lord. Your Lordship observed.
You lost an
execute the sale deed.
opportunity. You lost an opportunity.
Your Lordship may record that statement that they will,
You
within a
lost
week,
an
they will.
opportunity. The council, you must understand. Now you will file a civil suit, and then this will drag on for decades.
Lord, I will not, Lord. Your Lordship, they made a statement that
Lost a
they're ready.
golden chance of getting a sale deed executed in your favor.
Lord, your Lordship may say in this order that they subject to them
This
executing the
file,
sale deed. That's it, Lord.
this
in
file
within a week,
judgments by this court
Yes.
about this civil dispute, money transaction, I
No,
do.
I
it
bow down, Lord.
repeatedly
Lord,
so
please
that
see their conduct,
there is
Lord.
no multiplicity of litigation and the parties resolve their dispute here itself.
Lord, please see their conduct, Lord. I
If
bow
you
down,
don't
Lord.
seize the opportunity, what can we do?
Lord, they make a wrong statement before your lordships, and now, Lord, they are, Lord,
As a
fulfilling that
litigant
statement, Lord.
also, you should not only be a litigant, but a prudent litigant.
Lord, your lordship may kindly
You
bound
must
them with
know
the agreement,
about
Lord,
your
at least.
rights and your, as soon as
Lord, I bow down, Lord. Please see
you
their
get
conduct,
that,
Lord. They make a statement before your lordship and then they resign, Lord.
both of you want that the dispute shall continue for some time.
No, Lord,
Anyway,
we don't want that, Lord. They have
for
taken
you
my
to
money,
decide,
Lord.
for
At
you to
least they
decide,
should,
we do not know.
Lord, your lordship, it fell from your lordship that they, within a week they should execute. Lord, let that be recorded, Lord. It fell from your lordships, Lord. Lord, otherwise they run away with my money, Lord. They have taken anticipatory bill, they will run away.
They
So
are
please,
running away, and because of you are responsible for it now.
Lord,
He says
kindly.
he is ready. Both of you have an opportunity to go for mediation and resolve it. If it is a
Then,
matter
Lord,
of few lakhs
Lord,
only.
may I say this? Your lordship may keep it pending. We'll go for mediation here. Your lordship may keep it pending. Lord, because otherwise, Lord.
What about our fees? You don't decide between yourself. When we
Lord,
suggest something, you say yes, we'll do.
Lord, your lordship knows, Lord, once he gets anticipated bail, he will never execute the sale deed, Lord. And I have to litigate for so many years.
You must have realized this.
Lord, that's why I gave him a notice.
And you
I was there.
didn't utter a word when we were dictating the order. You kept quiet, as if you are
I'm so
happy
sorry.
with this order, like the earlier council.
No, Lord, I thought, Lord, I'm so sorry, Lord. I was under the
Oh,
impression that
they
your lordship
don't
was making them.
understand this advocacy.
Lord, I apologize, Lord.
Court is willing to accommodate and you are not ready.
I apologize, Lord. I could not understand that, Lord. I apologize profusely, Lord. Lord, your lordship, it fell from your lordship that within a week they will execute the sale deed, Lord. Let that be recorded, Lord. Otherwise, Lord, they made a statement before your lordship and now they are running away from that statement, Lord. Please see their conduct, Lord.
वो SLP डिस्पोज ऊपर लिखे हो ना पढ़ना पूरा ऑर्डर.
The dispute between the parties arose out of a sale agreement which, according to the complainant, has not been honored by the petitioner accused. By order dated 1st December 2025, we have granted interim protection to the petitioner. When the matter was argued, Learned Counsel for the second respondent complainant submitted that on 15 March 2026, he was present in the office of sub-registrar after informing the petitioner for execution of the sale deed. However, he did not appear before the office of registrar. Countering this submission, Learned Counsel for the petitioner submitted that the second respondent is claiming that he is paid an amount of rupees 97 lakhs.
He has paid.
He has paid an amount of rupees 97 lakhs to the petitioner over and above the earnest money of 35 lakhs shown in the agreement. There appears to be a dispute as to the payment of amount at the time of execution of the agreement. Be that as it may, that is
Full stop. Huh? Be that as it may, काट देना. Be that as it may, काट देना.
Be that as it may.
हाँ
the
वहाँ से
dispute between-
कट कर देना. उसके बाद हम लिखा दें है ना. There appears to be dispute between the parties. वहाँ तक लिखा है ना. Full stop. In view of the above, and as agreed by Learned Counsel for the parties, comma, they are referred for mediation to be conducted by the Supreme Court Mediation Center. Let the parties appear before the mediator appointed by the Supreme Court Mediation Center on 8th of May.
Not one clarification. There are 6 co-sharers who have to execute the same day. So 5 others we not may issue notice to them also because they have been granted anticipatory bail by the High Court now. Because I can only sell my share, but if the entire agreement is to be executed, but then 6 persons have to execute the same. This is my
This mediation should be here or before the.
it is better if it is at the.
So if this belongs to Punjab, Jaipur.
Yes, Lord. Yes.
If the SLP is being kept pending by my lords,
We are keeping it pending.
then my lords, it may be done.
We are keeping it.
This is how the practice is.
We are keeping it pending.
Not here only, not should just say that
Let the parties are.
all the
Let the parties appear before the mediator appointed by the Supreme Court Mediation Center on 8th May.
Let the parties appear before the mediator appointed by the. It is Rajasthan High Court Mediation Center.
Supreme
Punjab.
Court.
No, no, this is arising from,
Punjab.
Punjab and Haryana.
Punjab.
this is item 2.
Yes,
Please,
my
my
lord.
Punjab.
Punjab and Haryana High Court Mediation Center. Stop. It is in the center on 8th of May, so and so. Stop. Since there are 5 other signatories to the sale agreement,
Co-sharers.
They are co-sharer.
other
Co-sharer
signatories, oblique co-sharers to the sale agreement, comma, the petitioner shall join the co-sharer as respondents herein. And the said co-sharers shall also be involved in the process of mediation. Full stop. Post the SLP on thirtieth July for submission of mediator's report.
No, interim to
Highly
continue.
grateful.
Interim to continue.
Grateful.
Highly
Yes.
grateful.
Lordship, at the time of filing the FIR, the charges against me were under section 137 of the BNSS and section 1112 of the Volkswagen. Now, prosecutrix in her statement under section 160 and 164. Prosecutrix in her statement under section 160 and 164 categorically denied sexual assault or wrongdoing. Only in the supplementary statement dated 23/04/2025.
But the
the allegation,
DNA report is against you.
Your Lordship,
DNA report, FSL is against you.
Lordship,
In the salwar of the prosecutrix, your response are found.
Lordship, if we look
And
at
that
the,
is matching with your blood group.
Lordship, if we look at the entire
Even
circumstances, this
We
is
do
the
not know.
clear-cut case of consensual relationship. Your Lordship, in
No,
her-
consensual C16? What consensual? C16?
Lordship, in the similar matters, the Honorable Supreme Court only granted the bail.
There is no similar matter in bail.
Lordship,
Similar may be only when you are in jail since 5-6 years.
Lordship, I have already been in
Only
custody.
that, only on that ground there may be some similarity. Otherwise, every case is different.
Indeed, Your Lordship. Lordship, I have been in custody for 12 months and only 5 witnesses have been examined and there are 21 witnesses. And what I am saying is, in her cross-examination, she herself admitted that she was. Lordship, the phone which she was using was provided by the accused only, and for the past 2.5 years, she was in the constant relationship with the accused.
You see, that is the usual modus operandi of all such people.
Lordship, in case of
First provide phone and then
Lordship, in fact, the session judge in his own findings has written it that she prayed before the court of law that the bail should be granted to the accused.
minor dismissed.
For
The petitioner,
I have wait, to file my counter affidavit.
1 week per counter.
Allow me to join the investigation.
I am appearing on behalf of complainant in this case, my lord. Let the complainant be included as a party, my lord.
Let complainant be imputed as party respondent.
My lord, allow me to join the investigation.
Complainant. Complainant
Please, my lord.
may also file counter before the next date of hearing.
Grateful.
Say 2 weeks, post after 2 weeks, not 1 week. Why have you not joined?
My lord, because there is no order, my lord. Only arrest has been stayed.
Then
My
we'll
lord-
withdraw your interim bill.
My lord,
If you need our order to join investigation,
that I'm seeking unconditional
An-
apology, my lord.
an accused seeking a direction to allow him to participate. You should participate. You go
I will, my lord. Tomorrow,
call him
my lord, will
and interrogate.
please.
or my lords will fix any date, my lords. After a day or two, my lords, he will appear before the IU.
Yes.
We will not fix it.
My lords,
We will not monitor investigation. You know your statutory duties.
we'll do it. It's okay.
Please, my lord. Well, this is an application for anticipatory bail, my lords. Your lordships were pleased to protect me, my lords. My lords, during the pendency of the matter for the Honorable High Court, I have attended, my lords, almost on 15 dates. And my lords, after the order of your lordships also, my lords, I was called on 4 dates. I have attended. So my learned friend in the counter affidavit are saying, my lord, that I have not cooperated. My lords, the issue is, my lords, an agreement of registered agreement to sell was executed in January of 25. And finally, a sale deed was executed after almost a year, my lords, in November.
Yes.
Lordship, I have said in my counter that he has not cooperated because I have the instructions. He is appearing before the investigating officer, but he is not answering the questions. Also, on the last occasion, the petitioner had said.
On hearing learned counsel for the parties, we are satisfied that the interim order passed by this court
I am the
on
advocate of the complainant. I presented before the High Court along with District Court. Your Honor, I may permitted to file my representation in the matter because matter what is supposed to place before the Honorable Lordship is not as such as they show. In fact, matter consists
I don't follow
of illegal money lending along.
I have not followed what you are arguing. You are appearing.
Your Honor, kindly permit me.
You are appearing.
For the sake of, I may get permission. I am the representative of the complainant, Your Honor, before the High Court, the District Court as well. Your Honor, I pleaded for permission to give me a chance to argue on behalf of the real controversy of the matter is not as such as they are supposed to place. It is a simple transaction.
Let complainant be joined as respondent.
Highly obliged, Your Honor. Highly
All
obliged.
parties be corrected. Complainant may file his counter affidavit before the next date of hearing, post on 14th May. Interim to continue.
Right.
Six.
My lord, I am appearing for the petitioner, my lord. Yeah, I am appearing for the petitioner. I filed an application seeking permission, my lord. At this stage, my lord, may I submit that I am praying for the issuance of a notice for the limited purpose of the mediation, because reason being, my lord, I am told by the girl that both are willing to marry for XYZ consideration. That is not happening. Panchayat was also held, my lord. And both, I am not arguing on merits at this stage. Perhaps my life will be saved, because that is my humble submission. If the mediation takes place, my lord, perhaps the matter will be resolved, my lord, and my life will be saved. I am the, because I had no opportunity to tell anything either before the session court or before the High Court. This is first time I am before my lord, my lord. So I am praying for limited purpose of mediation. Yes, I leave it to my lord, my lord.
But you are challenging the bail granted to him.
Yes, my lord. That's
You
why
can
at the outset I made the submission, my lord.
So you can marry him.
Yes, my lord.
Stop you.
My lord, Panchayat was held, I have said in my petition, my lord. And in fact, they were about to marry, but for the consideration, my lord is aware in the village, my lord, that did not take place, my lord. So unless until the boy come before your lordship or before the mediation cell, so I am helpless. And first time I am before any court, my lord.
You want our seal to marry?
No, my lord. I am saying only let the matter be referred for the mediation, my lord. And for that purpose, I am requesting my lord to issuance of notice.
We have not opened a marriage facilitation center in Supreme Court.
My lord, then on merits,
you want to marry, you go and marry him.
My lord, stopped you. My lord, that I cannot unilaterally do unless until he comes.
Sorry, dismissed.
My lord, may I submit, my lord? Kindly then have kindly have then my lord, on
Yes.
merit, my lord, in 2020 the relationship took place. At that point
Yes,
of time,
yes.
Minor, my lord. I am a minor girl at 2020, my lord.
Permission to file that.
My lord, may I submit? My lord, may I submit, my lord? Only one line.
Next, we have already dismissed.
My lord, only one line, my lord.
Yeah.
my lord, 2020, I was only 16 years old. Page number 3 of the impugn order, my lord, and I told this fact before the magistrate when my statement was recorded, my lord. And the anticipatory bail has been granted, my lord. Page number 3 of the impugn order, only one line, my lord, I will show.
That is exactly
Page number
the
3 of the
reason
impugn
why
order.
anticipatory bail granted should not be confirmed.
Wait, please.
Yes, next.
The union has challenged the order granting bail only on the reason that it is not only under section 67, which the Honorable High Court is saying, but it is a prima facie case also. Now let's kindly see page 89 in our complaint, where this respondent has stayed with these accused in the hotel. We are saying it is an overall conspiracy, drug trafficking case, and she's the main conspirator. She's just been inside 7 months, and on them after from those 7 months, 3 months on medical bail. Only the custody period is 4 months, and she's the main conspirator. Just see page 89 of prima facie case. Let's kindly have, if I may just read.
Delay.
That of course
If you are so serious about it,
we have to come at the earliest, my lords. I bow down.
you should come always.
But this
See,
is a very
52 days,
serious case.
not a delay of few weeks.
I bow down, my lords.
See, 52 days delay.
I-
And you are arguing so seriously.
My lords, NDPS cases.
Why your officers are not so serious when the bail is granted?
3.5 kg heroin, my lords.
See, you want any further comment on your officers?
No, my lords, it's a delay. I bow down, my lords.
Not delay. You are saying so seriously. You are very, very serious about 3.5 kg heroin.
You should have come earlier, my lords.
It should have moved your officers at that level.
You should have come earlier.
We will impose cost to be recovered from that officer who has not filed it and issue notice. If you are ready, we will impose cost.
We cannot do that, my lords.
No, while you see, we have to condone the delay. And if we condone the delay, there has to be some terms. No. Dismissed on the ground of delay.
Well, it's then an observation that in case, my lords, there is anything adverse we find against the respondent, we can come again, my lords. Because the trial is going on, and in case it is delayed or something, then we can come. Because otherwise, my lords, the bail is in a sense confirmed.
No, I have not followed. If the trial is delayed,
on account of the respondent not, my lords, coming regularly or delaying the trial, can we? I'm just asking for that, my lords. If we can come again, if there is
seeking cancellation.
Yes.
On the ground that they are not cooperating.
The respondent, my lords.
Yes, they are respondent are not cooperating.
Yes, because the trial is now going on. So I'm only humbly requesting, because once the bail is given by this court, then
that we can't do. Because for such observation, we have to condone delay. Otherwise, we cannot consider on merits and make observation. And once we condemn the delay, then difficult.
Well, so any post conduct, I'm just saying that after the bail is granted, if there is any post conduct which comes to our notice,
dismissed on the ground of delay. However, if the respondent does not cooperate in the trial, the petitioner would be at liberty to move before the High Court seeking cancellation of bail. Yes. Next.
Wait, please, Lord. This is a case we will get to appeal for the complainant.
Yes.
Now, this is a case wherein the court says it's a civil dispute, and because I agreed for mediation, I'm not interested in prosecution with the greatest of respect. Because mediation was sought by the other side, and whenever your lordship ask the parties to go for mediation, we never say no, Lords. Part 1. Part 2, Lords, the accused says that he was in 2023 was 62 years of age, and I, who is 65 years of age, have given him a soft loan of 1.5 crore for 20 years at the rate of 4%. Lords, thrice the IO, twice he has gone for investigation. Twice status report has been given by the IO.
Mediation has also failed.
Mediation has failed. Court says, court is taking a contrary. You're saying, why did you go for mediation? Look, when your lordship in any matter asks us to go for mediation, we will never say. And it was the accused who had sought mediation. We had to.
What is wrong in granting bail?
For the reason, Milord, kindly see the status, please status report. Continuously, this man, the first kindly see the first interrogation report at 101.
It's a money transaction.
Milord, it is a money transaction. What was there, Milord, is that I have been duped. Now, Milord, kindly see the first interrogation report at 101. Therein, Milord, he gives wrong statement, Milord, before the IU. He says there is no criminal case pending against me. He says I have only 2 bank accounts. In the next investigation report, Milord, he says no, there are 2 cases, previous FIRs pending against me. He says yes, I also have a bank account. He files a document, Milord, wherein the IU has given a report that a notarized document has been
the total amount involved.
From me, 1.5 crores, admittedly, and he says, I at 65 will give him for 20 years. I will not see the day after 20 years.
20 years?
Yes, he says so. That the complainant, gave him the money because he is my niece's father-in-law. That is my Sala's samdi. So he says, I gave him 1 crore of rupees for a period of 20 years to be invested. I am 60.
Sala ka samdi, it is too complicated.
That's exactly.
Dismissed.
Milord, we kindly appreciate. I have given, there's no dispute. He's admitting the money has been given to him. He's not saying that money has not gone. It has gone by RTGS, Milord. Today, Milord, the High Court says that why did you go for mediation, Milord? Now, please see the order of the High Court, Milord. The complaint.
Sala ka samdi, and you are not able to
Milord,
mediate and take it.
Milord, for the reason, he is not coming. In fact, his son has lodged an FIR against him. He is saying things against his son also. Milord, please see the order of the High Court, Milord.
His son means your Sala.
Sala's damad.
Sala, they're complicated.
Milord, that's the problem. Milord, kindly see the order of the High Court, Milord, for a minute. What have I done? What's wrong in what I have done, Milord? Page 220.
Since it is in the family itself, there may be some mediation.
Lordship, please.
Notice.
My lord, perhaps one thing my friend
You are also
should
here.
want. I'm supporting him. But all I'm saying is let the observations of the order, observations in the order may not be my lords, adversely affect the rights of the case itself.
No, we have issued notice.
Oh, may I please?
Yes, we have issued notice. Yes.
Deeply obliged.
May I please?
31.
Please, Lords, I'm requesting a short accommodation in this matter, Lords. The arguing counsel is in some.
Anticipatory bail you are seeking.
Please, Lords.
What is the total amount?
Lords, Lords, it is 27 lakhs. Lords, the issue here is I'm no way involved.
You see, you first file a better typed copy of the impugn order.
Please, Lord, I will.
Then counsel for the petitioner is permitted to place on record typed copy of the impugn order which is not legible.
Lords, I'm only requesting permission to be given to file some additional document. But other co-accused have.
He may also file some additional documents. He may also file additional documents. As prayed. Post after a week.
The petitioners are cousin father-in-law and cousin mother-in-law. She
Huh?
committed suicide. They have been
Anticipatory bail, dowry death.
Yes, they have been living separately. There are 6 persons. The offense has been registered. They are the residents of separate and the allegations are against 6 persons. She had committed suicide, and there is also in the FIR it has been mentioned that she was in relations with another person and she used to talk with the person on phone. This has been mentioned. The CGR calls and phone calls have also been mentioned. So for as present petitioners are concerned, we have submitted details that they are nothing to do with that allegation. Father-in-law not father-in-law, cousin father-in-law and cousin mother-in-law of the deceased. The High Court has only dismissed the application because earlier application was dismissed as good cause. On this reason, the High Court has dismissed it. Kindly see page 29. We have submitted the detailed documents that these persons have been living separately. There was partition in the family.
No, the deceased was living in which village?
Deceased was living in the same village, but they have been living, the house is different. The applicants are separate and no direct involvement day to day. Panchanama, prepare certificate, Gram
So you are the mother-in-law and father-in-law?
No, madam. Cousin mother-in-law and cousin father-in-law. Chacheri means uncle, the wife of, he is the uncle of the husband of the deceased and auntie of the husband. Mother-in-law and father-in-law, they are separate. They have also been accused. The sister-in-law has also made accused. There are 6 persons have been accused. And the allegation is this: a motorbike was demanded, and there was a demand of
What is the allegation against you?
Omnibus that a demand of dowry was made. And kindly see the FIR. This fact has been mentioned that she was in continuous contact with another person. She had also talking with him. Rahul Yadav, phase 20. Rahul Yadav, phase
20.
Lordship, phase 20. Okay, this is FIR. The name of suspected Rahul Yadav was mentioned along with mobile numbers whose CDRs was obtained from cyber cells. On verification, the mobile subscriber was found to be Rahul Yadav, son of Sundar Yadav, aged about 19 years, resident of village Bhav, district Faizabad. Thereafter, a team was dispatched from police station. Suspected Rahul Yadav stated that he had conversations with deceased Sudha Lodhe on mobile number WhatsApp, Telegram, WhatsApp, Instagram, and SafeChat prior to marriage as well as after his marriage. He also stated that deceased Sudha Lodhe had informed him that her husband Viren Sodhi had an affair with another girl. This is the allegation against husband. There is no allegation against the present petitioner. Thereafter, there are simple omnibus allegations that in demand of the abortion. This is only. Never had face-to-face interaction. Her husband, Biren Singh Lodhi, had an affair with another.
Petitioners are the uncle-in-law and aunt-in-law of deceased. What is her name?
Sudha.
Sudha. This is Sudha Lodhi. Who committed suicide on 20th September 2025. Considering the content of the FIR, we are inclined to issue notice to the respondent and direct the petitioner's release on entering bail in crime number so and so. PS so and so. We are inclined to issue notice. We can
Yes, Lordship.
issue notice and grant interim bail. Post the matter on during partial working days. Yes, next.
An application for regular bail, my lord.
302.
Please.
You caught hold of the deceased.
No, not the decision. But my lord,
You got hold of the deceased.
my lord, not the deceased, my lord. There are two victims here. I thought there's one deceased, not the deceased. The allegation is that I exhorted the co-accused to fire the shot. But if I can only submit for your lordships, the High Court says that there is no change in circumstance because we withdrew the first bail application. In fact, we came back to the High Court, my lord, almost 2 years later. I was on interim bail. And my lord,
It's a notice to the respondent.
I'm late.
I appear according to the
Mr. So and so and counsel appears an access notice for respondent state of Haryana. Let counter affidavit be filed in 6 weeks. Post the matter during partial working days.
My lord, we were only one other request, my lord. His sister is getting married on the 27th, my lord, of this month. If your lordships can call for their in such a manner that I can attend the marriage of the sister, I'll be very grateful to you, lord.
27th
Of April.
Not possible.
My lord, if your lordships will, I'll be most grateful, my lord. It will enable him to fulfill his duties as a.
Yes.
And
बाकी हो गया ना complete?
So I'll straight come to the point. The objection on maintainability of Article 32 can never be tested as an abstract proposition of law. Maintainability of any proceedings necessarily depend upon the facts of each case. In some cases, it may be maintainable. In some, it may not be maintainable. Therefore, my lord, some facts would be relevant. But please come to writ petition 16 of 2026.
Well, once again, with great respect, an officer of the court, and the highest regard for your lordships. We are on maintainability. And all submissions advanced by respondents' counsels have only been on maintainability, not factual parameters.
He's arguing on maintainability.
Yes,
I am
only
arguing on maintainability,
and
but
facts.
I am
my
not
lords. Please
delivering.
get started on facts.
I am not delivering a lecture on maintainability in general.
My friend is using your lordship's proceedings as a social media weapon in a political campaign. My lords knows this. My lords knows this.
We saw it.
Lord, it is.
Your lordship must be disappointed by
I am not disappointed. Now sit down.
Your lordship,
Now,
don't talk to me like that. I'm not your underling. Do not talk to me like that in a courtroom again.
This is not the way.
No, how can he say this?
She talks to every law officer like this.
How can he? How
This
can he
is
say
increasing, but
how
not
can he say
again.
this? Just sit down.
Again, my
Does he
responding
talk
would
like
not
this too?
glorify
Is he allowed to
the
talk
behavior,
like this?
and therefore,
Who uses proceedings in your lordship's court on social media and a major political party posts it?
it is posted because you compared your
How
government.
your lordship's
This is
court
not-
is abused. I did not compare this to anything.
Yes, be confined to the submissions.
But I am
Yes.
submitting, but now
And
nobody.
please don't abuse the proceedings in this court as a tool to be used on social media.
Now you can use it. I have
A
nothing to
tool
do
to
with
be used
politics.
on social media. You don't have anything to do with politics.
But
You don't have anything to do with
never
politics.
ever compare in a
Please.
democratic country
Yes.
with anyone, either
If
as a
you-
crown
if
or as
you
a queen.
understood what
Otherwise,
I
I
said,
object to.
I was talking to a
What is this?
pre-constitutional position. The only persons behaving like the crown is you. You behave like an unelected crown and a monarch. And do not ask another lawyer.
Lord, a very dignified silence can be the only answer to this kind of behavior. Let us start with
Be
the.
silent then.
Let us start with the matter then. I cannot, behave like a strict fighter.
My
Can we
lord,
come to
either
page
he is
1?
dignified or he is silent.
Page 1
He is
now,
neither
please
of those.
allow me.
He is neither of those. That's the problem.
Lord,
You please continue.
he has to prove something somewhere, my lord. I have nothing.
Only person proving is you, Mr.
yes.
Mehta. You don't have the legal arguments. You turn to social media.
Take your seat. Let it.
Grateful, my lord. I'm always happy to appear before your lordship. Your lordship knows this.
Why do you compare the word inside the court and outside the court?
My lords, what is
Lord,
inside your
any
lordship's court
fact
is supposed to have
is
sanctity.
beginning of another argument.
Your lordship's
What-
proceedings are
what-
supposed to have sanctity.
There is-
The Solicitor General cannot say sit
You see,
down
the
to
whole-
an opposing
The
counsel.
whole
I'm sorry.
difficulty is that we try to hear the arguments silently.
Well, let me start. Let me start in my the way she wants.
Because the whole
If-
difficulty
I-
is that we can't stop the media. And once we start saying anything,
Yes.
Yes.
then it is picked up. Now it is,
Nobody can
Please
control
circulate, my lord.
it is live.
Please circulate.
It is live.
Please circulate.
Either party uses this and
Yes,
the
please circulate, my lord.
at times it becomes
I'm
difficult
not
for us
please,
Yes.
anyway,
whether to
I'll
say
not-
anything in
Yes,
court
my
or
lord.
not.
Not
Your
anything
lordship would
further,
have this either.
anything further
follow
to encourage this
I
kind
have
of
been in
behavior.
so
What
many
your lordship made.
other matters before your lordships. I know your lordships is pained by how this courtroom's proceedings are being used, but that is what they're doing.
Please proceed.
Yes, madam. I would like to cite Lord first Rigved. Have you got? No, it's not there. Then I'll come to my Lord Chandogya Upanishad. You have? It's again not there.
What is that? Chandogya.
Chandogya Upanishad.
Chandogya.
Yes, Lord. Then I'll come to Lord, I'll go historically, and thereafter your lordship need not write.
No, this
I'll
I'm
come
giving.
to 1919, Lord, 1915 Government of India Act, but that again my friends have not got.
This Upanishad I am coming across for the first time.
Yes, my lord. I also came across for the first time.
Yes, yes.
Lord, then I'll come to 1915 Government of India Act. Then I'll come to 1935 Government of India Act. Then I'll come to 1947 Indian Independence Act. Then I'll come to my lord the Constituent Assembly debates. Then Lord Servile. But they felt that that's absolutely irrelevant, so they have not brought it. And I agree with them. Therefore, now I come with the effects of this.
You are giving it in the same coin.
No, I am not giving anything to anyone, my lord. I choose my lord friends and foes. Please have a look
Mr.
at
Mehta, Mr. Mehta, some of your friends should be supplied a soft copy. That's all.
Yes, no, they have not brought. I am not citing. I am not
Oh,
citing. Don't worry.
no difficulty. No difficulty.
Lord, kindly come to page 1. Lord, this is not, my lord, a general debate on 32 and how 32 is maintainable. 32 is always based upon the fact-specific situation. Page 1 of the writ petition, Lord, that is 16 of 2026. I understand the pain of the respondents that they would not like your lordships to see some of the facts based upon which I would show. This is why 32 is maintainable. It's really embarrassing to face these facts, my lord. And therefore, I do understand, Lord, what is the pain. But still, it is my duty, my lord, to bring to your lordship's notice to substantiate my contention that Article 32 petition is maintained. Now, my lord, let us have come to page 1. Lord, kindly see, there are two petitioners. Lord, everything was argued that ED is not a statutory body, ED is not a person, ED is not a citizen, ED is not this, ED is not that. Correct, my lord? Without being told that your lordships were never told that petitioner number 2 is my lord Robin Bansal, Deputy Director, HUV, my lord, that is Head Unit, Directorate of Enforcement, having office at so and so, so and so. Correct, my lords?
Yes.
Now, at this stage, my lord, please also have a look at the second petition, which Mr. Raju will be arguing, my lord.
Second petition.
And we will be confining to the facts of the case, my lord, not a general discussion, my lord, on the contours of Article 32. Whatever is relevant for the present case, I'll present it. And please, you have the list. Lord, kindly just see the names and I'll connect, my lord, how their fundamental rights are violated and what are the averments made in the petition.
The second one?
Second.
Nishant Kumar.
Yes, my lord, the writ petition 17 of 2026.
Yes.
Nishant Kumar, son of Devi Ram so-and-so, working as Assistant Director, Directorate of Enforcement. Then Vikram Ahlavan. Please mark I'm sorry, page 1. Vikram Ahlawat, son of Rampal Singh, aged so and so, currently working as assistant director. Then Prashant Chandalia. Please, my lord, just bear, my lord, these names in mind. Something turns on that, my lord. They are before your lordships. He is assistant director, Directorate of Enforcement. Then, my lord, respondents are same. One is State of West Bengal. 2 is the Honorable Chief Minister. 3 is the Director General of Police, the then Director General of Police, but now he is member of Rajya Sabha. 4 is, my lord, the Police Commissioner. 5 is, my lord, DCP. And 6 is the Central Bureau of Investigation. Now, please come to para 5 of my petition, my lord. Para 5.
The first petition.
Yes, first petition. How, my lord, this started? My lord, ultimately, my submission is going to be that there is complete and total failure of law and order situation in the state of West Bengal. This is my legal submission, whether someone may like it or not like it. Rule of law is a part of Article 14, which is a fundamental right, and I will demonstrate how that rule is violated, which makes the petition maintainable. It's not a political platform. I am not, my lord, trying to, my lord, please anyone, and therefore I'll confine to the legal submission. Para 5. During investigation, Lord, kindly note one aspect. Lord, this is the investigation which we are doing under the orders of the Honorable Supreme Court. But one of the investigation, Lord, which I'll refer to. Yes. Lord, here, this is a case where there is an illegal smuggling of coal from the central government's coal refineries, and the total amount runs into some 2,000 crores. 2,700 crores. And we, the ED and their individual officers who are also citizens of India, and they are discharging their statutory functions, they are before your lordship, giving these facts to your lordships and seeking my lord's protection for protecting their fundamental rights. During investigation, it was gathered that the illegally excavated and stolen coal used to be sold to Shakambari group of companies. On analysis of documents seized from premises of so-and-so, it revealed that Maji Group used to receive cash from Shakambari Group against sale of illegal excavated coal. Shakambari Group companies are primarily into steel manufacturing. The group is led by so-and-so. Then kindly come to para 7. Further investigation regarding the utilization of POC, means blood proceeds of crime. This ought to have been pointed out to your lordships when I was in 32. Because 32 can never be decided as an isolated, abstract legal proposition. Dr. Ambedkar never conceived of this situation. Further investigation regarding the utilization of proceeds of crime was undertaken, which revealed that the proceeds of crime generated from coal sales were utilized by sending the proceeds of crime through both domestic and international hawala. One such hawala operator used by coal syndicate to transfer proceeds of crime has been identified from WhatsApp chats of so-and-so, accountant of so-and-so. Hawala firm name so-and-so was used for hawala transfers by the coal syndicate as seen from WhatsApp chat dated so-and-so between Neeraj Singh and Ashok Kumar Mishra. Then 9. Material evidence have been gathered which discloses 20 crores of proceeds of crime arising from the illegal coal mining were used through interstate hawala networks layered through a chain of facilitators, converted into cash at Goa and channeled into, please mark this, my lord, I-Pac. The raid in question was on this, my lord, based upon the chain of investigations and the material gathered. And I-Pac, my lord, is operational framework by being handed over to persons executing the work. Now, my lord, may kindly closely read para 10. Thus, the such proceedings were started at 10 different premises situated in Delhi and Kolkata on 8/1/26. Out of the said 10 premises, one of the premises was the residence of Mr. Pratik Jain, situated at so-and-so Malik Bazar, Park Street area, Kolkata. Please mark this name. Sri Prashant Chandalia. My lord, he is petitioner number 3 in the second petition which Mr. Raju is, Lord, assisting your lordships with. Assistant Director was authorized by Sri Robin Bansal, my lord, petitioner number 2 in the present matter. Deputy Director with the authorization number dated so-and-so to carry out search and seizure proceedings at the said residential premises of Mr. Pratik Jain. My lord, we have placed on record the authorization letter. They were not Tom, Dick and Harry who entered, which required, my lord, the respondent number 2, the Honorable Chief Minister, to barge in and, my lord, collect the evidence which I'll show. And my lord, snatch the evidence which I'll show. Then 11. During the course search proceedings at the office premises of Mr. I-Pac Consulting Private Limited and residential premises of Mr. Pratik Jain, certain police personnel had arrived at their respective premises and asked the officers conducting the search to intimate local police station if they wanted to continue this search. During the course of search at the residential premises of Mr. So-and-so situated at so-and-so. Now, my lord, this is residence. Earlier was the office premises. Various digital devices were taken into possession which were suspected to be relevant to the PMLA investigation. During the course of search at around 11:15 a.m., Sri Priyo Brato, IPS, Deputy Commissioner of Police, South Kolkata, visited the building premises. Now, let's see the power of this man, my lord, who is guilty, at least prima facie, of having, my lord, been a part of this Hawala network of 20 crores. The Deputy Commissioner of Police comes, South Kolkata, visited the building premises and informed the authorized officer that a complaint of house trespass has been received by the police. Thereafter, for the verification of correct facts about the proceedings, the DCP was shown the identity cards of the team and search authorization letter. This is what, my lord, is not in dispute. Thereafter, Sri Manoj Kumar Verma, the Commissioner of Police, Kolkata, also entered the premises. As the police officers were being briefed about the search proceedings under Section 17 of PMLA at around 12:15 p.m. This is an admitted fact, admitted by the Honorable Chief Minister in an affidavit filed before your lordship. I'll show. PM, so-and-so, identified, entered the premises despite making categorical request for not interfering with the ongoing search proceedings under PMLA. However, violating all law and order, Miss So-and-so, with the aid of police, forcibly took possession of all digital devices and key incriminating documents from the possession of the authorized officer, Mr. Prashant Chandalia, Assistant Director, and left the premises at about 20:15.
He is one of the petitioners.
He is one of the petitioners. And he is now, Calcutta, West Bengal police has registered a case against him. I'll show that. Those FIRs are under challenge, and we are saying, my lord, and I'll say something further, that now direct in the entire investigation to be conducted by a neutral agency. Well, all the proceedings have been recorded in Panchanama duly drawn at the premises on 8th January 26. An incident report dated so-and-so was also drawn at the said premises by the authorized officer who was conducting the search. True copy of the Panchanama. Please see, my lord, now 13. It is further submitted that another premises out of the 10 premises searched by the Directorate on 8th January 26 was the office premises of I-Pac Consultancy Private Limited, situated at so-and-so, West Bengal. Sri Vikram Ahlawat, my lord, is petitioner number 2 in Mr. petition where my learned colleague would be assisting your lordship. Assistant Director was authorized by Sri Robin Bansal, Deputy Director, petitioner number 2, my lord, of this petition, with the authorization number so-and-so, dated so-and-so, to carry out search and seizure proceedings at the said office premises of Messrs. I-Pac under section 17, and proceedings of the said search and seizure operation were recorded in Panchanama dated so and so drawn at the above mentioned office premises of Messrs. I-Pac. However, the officers of Enforcement Directorate were not allowed to perform their lawful duties and were obstructed to carry out the same. Hence, an incident report dated so and so is drawn. Now, my lord, what is that incident report? Please come to page 79. Page 79, my lord, contemporaneous report. It starts at page 77 in presence of independent panchas. And my lord, I'll just read the relevant part at page 79. Complete absence of rule of law, and I say that because rule of law is a part of Article 14. Article 14 is a fundamental right, and I can maintain a 32 petition, my lord. Meanwhile, during the search, the Honorable Chief Minister so-and-so, Miss so-and-so, Srimati so-and-so, along with West Bengal state authorities and several senior-most police officers entered the premises around 12:40 p.m. So 12:15 is at residence, when 12:50, the Honorable 40, the Honorable CM comes at the residence office premises. During the search proceedings,
This you are reading 79.
79. I'll read below the third unnumbered paragraph.
Yes.
Below 12:10, the Honorable Chief Minister left the residence. 12:15, I'm sorry. And at 12:40, Lord, she, along with about 100 police officials, DG, and I'll show Lord, the DG was there, police commissioner was there, several DCPs were there. They come Lord, now to the office premises. Meanwhile, during the search, the Honorable Chief so-and-so, along with West Bengal state authorities and several senior-most police officers, entered the premises around 12:40 p.m. During the search proceedings, the aforementioned state authorities, police officers took away the documents collected and indexed by the ED officers. Moreover, the backup of the computer system and email Ishan Taneja and so of Ishan Taneja was also stopped midway, and the state security officers took away the said computer system of Sri Ishan Taneja. The storage device of the security cameras installed in the premises was also taken in possession by the state security police officers. The state security police officers also took away mobile phones of employees of I-Pac. Please see. The person who was under investigation, who was being raided, and who was a part of the criminal syndicate, according to our investigation, my lord, is being protected at that level in this manner. I-Pac Consultancy Private Limited present at the premises. Now, my lord, coming back to para 9, page 9, sorry, para 4. Para 14, your lordship gets to know.
Yes.
It has also come to the knowledge of the petitioner herein that several FIRs have been registered in a malicious manner, targeting officers of the Directorate of Enforcement only for carrying out their official functions under the PMLA and to criminally intimidate them. Some of these FIRs that the petitioners are presently aware of are as under. We were not having copies, my lord, of these FIRs, which we got subsequently, and we have filed, my lord, by way of additional documents the moment we get. Your lordship right now need not go into. There is no, they have said officers of the PMLA. But officers of the PMLA means those who are authorized in writing and who are on the site, who are before your lordships. Now please come to my lord, para 17. Now, my lord, we approach the Honorable High Court by way of a petition. Page 11, para 17.
Yes.
Before the matter could be taken up, an entire crowd and ruckus was orchestrated inside the court through a WhatsApp group by supporters and sympathizers of ruling party in West Bengal, whose chief minister had earlier obstructed free and fair investigation by ED in the offense of money laundering and has forcibly taken possession of digital devices and incriminating documents from the search premises, compelling the ED to approach the Honorable High Court by way of present writ petition. But thereafter, the true copy of the screenshot showing that the ruckus was orchestrated inside the court through a WhatsApp group is annexed herewith. Lord, WhatsApp group of the party in power. And therefore, the court passes the order which is on next page, page 12. This is what the Honorable Learned Single Judge says. The matter is taken up, Lord, in the quoted part, my Lord Justice Anjari against me. The matter is taken up for consideration. At this juncture, a huge number of learned advocates as well as other persons enter the courtroom and create enormous disturbance and commotion. Several requests made by the court to maintain the decorum and dignity of the court so that the matter can be taken up for consideration fell on deaf ears. This is not my submission or my assertion. The Honorable Judge records it. The environment in the courtroom is not conducive to commence or continue with.
How do you correlate to this maintainability?
One of their ground is that go there. One of their ground is go to the alternate. And I do not wish to, I do not like to create an unpleasant situation. On the next day, there was a hearing. The Chief Justice of India had to pass some orders. The Chief Justice of the High Court had to pass some orders where, my lord, some derogatory words were used against my learned friend and made viral. But, my lord, we are immune from that. Law officers are supposed to be immune, and any response from us signifies something, my lord, which is abhorrent. I leave it at that. Now, kindly come to, my lord, page 15. Yes, page 15, my lord.
You just read para 18.
Yeah, yes. No, I read. Yes, para 18, the order of the para 18 and, my lord, 20. 20, I have quoted 20. That we did approach the High Court. It's not as if we have rushed here. The High Court records that it's not conducive to a fair hearing. We cannot start or continue the proceedings. And thereafter, my lord, I'll again show, my lord, what happens when
this we have referred while receiving notice.
Absolutely, my lord. Your lordships have virtually said that these arguments of Article 32 not maintainable is virtually, my lord, decided after hearing them. But nonetheless, they do
not decided. That was only a
prima facie. I bow down.
Since we are taking cognizance of the petition, there has to be some
Yes, but
satisfaction.
But the attempt is that the facts are so embarrassing that don't go into 32. Therefore, Dr. Ambedkar, Mr. Sirvai, this, that, and others. But I am only on facts. Now, please see page 15. Because during the search on 8/1/26, the facts of this case are embarrassing, and therefore they are relying upon the great Dr. Ambedkar. But if the great Dr. Ambedkar, hypothetically, I always say, please, ma'am, Mr. Please sit down. Please, I'm requesting you to sit down.
Why
Please.
should you request me to do anything?
Please.
I'm in my lord's courtroom.
But
Why should you request me to do anything? I mean, since you got in Dr. Ambedkar.
119. Before I come to about page 15. One one nine. My lord, the WhatsApp message, my lord, which I have.
We are off the track in this.
Huh?
Yes, please.
We're discussing something else.
Yes, yes.
Yes, sir. Obviously, my lords were discussing something.
119.
Yes.
Legal minds.
Yes. My lord, I am in position of a my lord, Mahabharata scene. 119, my lord. Please have a notice. Today, 9/1/26, court number 5, item number 10. Come everyone. My lord, he is my lord, so and so, convener High Court, my lord, of that particular political party. Gathering today at 1 p.m. at B gate. Come everyone. We'll go to procession of Honorable CM. Bus and vehicles are arranged. Read it with the order of the learned single judge that not only lawyers, others have also come, and it has become completely impossible to conduct the proceedings.
No, this is inviting for this procession of CM or in the court?
No, both. In the morning, come to the court, and 1 o'clock, buses are arranged. We will have to go to CM's rally. That's the. Lord,
it is two parts, para 1, para 2.
He is Lord, the lawyer and politician both. So he is discharging both the functions, and when we do that, Lord, difficulty arises. Now, page 50. Para H. Because during the search on 8/1/26, which was being conducted peacefully and in a lawful manner until the Chief Minister of West so-and-so, along with the DG Police, West Bengal and Kolkata Police Commissioner, and a force of about 100 policemen barged into by committing criminal house trespass at the residence of Pratik Jain, where the search was going on, and illegally committed theft and forcibly took away documents which were taken in possession by the ED officials conducting the search. The following conducts, my lord, we have said what are the offences, my lord, which are made out. Now, please come to, my lord. This is not, my lord, an isolated case that we rush before your lordships. Lord, this can be brushed aside as an isolated case. Lord, I have made out a case that in the state of West Bengal, Lord, such a beautiful state, Lord, considered to be the cultural capital of this country, Lord, what is the position, my lord, it has been brought to, and that is what I want to show. There is a pattern of complete breach of rule of law, my lord, that your lordships would find at page 90. This is not an isolated first of its kind incident. Well, the Honorable CM barges into an investigation is thwarted. Investigation by the lawful authorities are thwarted. Para, my lord, Roman 6. It is submitted that the CBI is conducting an investigation under the judicial orders passed by this honorable court. My lord, we are an extended limb of this honorable court in this particular case. In pursuance to the said, I am talking about now CBI, what they faced. In pursuance to the said investigation, the team of CBI officials, my lord Justice Anjari, page 19. Page 19, Roman 6.
Roman 6.
Just to show that this is a pattern.
Yes.
And therefore, I have made averments that please take cognizance.
This is some other investigation.
Not
this
some other investigation by the CBI. But modus operandi same, individuals involved same, and the pattern is same. To show that present incident is not a standalone isolated case. It is a pattern. The rule of law is the rule. Absence of rule of law is the rule. Lord, page 19, first sentence. The present incident for which prayer is made for registration of FIR and investigation by CBI is not a solitary incident of such nature wherein the respondent number 2, the Honorable Chief Minister, has misused the state machinery to criminally intimidate officers investigating serious offences against her or her party members. It is submitted that it is a matter of record of the court proceedings that the respondent number 2, the Honorable Chief Minister, has made a pattern to take law into her hands and misuse the state police wherever whenever any crime is investigated which is not of her liking. Then, my lord, next para. It is submitted that CBI was and is conducting an investigation under the judicial orders passed by this honorable court. In pursuance to the said investigation, the team of CBI officials wanted to visit the then police commissioner. Lord, the then police commissioner in the present case was the Director General of Police. Was. Now, my lord, he is a member of Rajya Sabha from, my lord, the same party few days back. Shockingly, respondent number 2, that is the Honorable CM, came with a huge police force and sat down at the main gate of the residence of the police commissioner. The CBI officers were arrested by the local police and were taken to nearby police station and intimidated. It is again a matter of record that neither the police commissioner was permitted to be interrogated on that day, nor his premises was permitted to be searched. In yet another shocking incident, this is not a this is a pattern, not an isolated case. In yet another shocking incident, the respondent number 2, the Honorable Chief Minister, barged into the regional office of the CBI along with heavy police deployment and a large crowd which was constantly pelting stones at the office of the CBI office at Calcutta. Simultaneously, a large crowd, I'll read the affidavit of the joint director. In that case, what he faced in this case, please have a look. Simultaneously, a large crowd was sent at the residence of the joint director CBI. The crowd gathered and started thumping the door and window violently to get it open. The joint director had to frantically make telephone calls to save himself and his family. It was only after the central forces reached to his rescue that he was rescued. Lord, at this stage, Lord, please have a look at his affidavit, which was filed in different proceedings, but regarding this particular incident, my lord. Please have a look at, my lord, the affidavit, my lord. Lord, IA, my lord, there is an additional document filed long back, IA, my lord, 65087. And look at the agony he went through along with his family members.
IA 6508. Yeah. 6508.
But this is on 32, that when there is a repeated failure, a pattern of failure of law and order at the hands of those who are supposed to maintain it, protect it, and respect it. Lord, 32 is a duty, it's not just a right. Lord, that's the judgment, Lord, your lordships have said. And I'm going to rely upon that judgment. Lord, here, this is the incident where the CBI officers were arrested by the local police. They went to interrogate the police commissioner. Now, Lord, what happens to the joint director stationed at Calcutta, joint director of CBI at Calcutta, page 97. Lord, one Partha Mukherjee, kindly, Lord, bear in mind, nothing turns on that, just to, Lord, page 97. Lord, this is an affidavit which starts at page 96. Affidavit of Pankaj Kumar Srivastav, joint director, Kolkata. In that case, Lord, I'm just showing, Lord, what is the level of, Lord, failure of rule of law. And rule of law is a part of Article 14. Para 3, Lord, at page 97. I state and submit that as soon as I was given the said information by Sri Partha Mukherjee, so he's SPCBI stationed at Lord, Calcutta, that our people are arrested and the crowd is coming to you with police force. I closed the doors and the curtains of my house. Your Lord, my Lord Justice Nanjaria gets of my house. I state and submit that by the time we could close the doors and curtains, the police personnel of Calcutta Police had already reached my residence. I state and submit that the police personnel at first started banging at the main door of my house, and soon the sounds of their shouts of their wireless sets could be heard from outside my house. I state and submit that I immediately telephonically informed my seniors in CBI head office in New Delhi and requested them to contact the union government and ask the officials to urgently approach the Honorable Supreme Court, as I, along with my family, was in complete state of lockdown. I state and submit that due to the siege and lockdown of my house at the instance of Calcutta police, I was unable to move out and check the security and safety of my officers and the offices of CBI. My wife and daughter were terrified with the menacing shouts of the police personnel outside. I state and submit that police personnel kept banging on the main door of my house and kept shouting from the outside the house. I state and submit that the said siege of my house under the aforementioned circumstances with clear intent to harass, intimidate, threaten me, and to apprehend me continued on for more than 2.5 hours in total. I state and submit that in light of the above-mentioned facts, the assertion that the police personnel gathered around my house for security purpose is an attempt to obfuscate. Then, para 4 is important. I state and submit that fearing the security and well-being of CBI officers and my family, I made attempts to contact the Chief Secretary of West Bengal, but could not reach him over the telephone. I state and submit that while the above-mentioned siege was going on, I received a few phone calls from journalists who informed me that they were not being allowed to come closer to my residence at Nizam Palace complex by the Kolkata police. I state and submit that I narrated the ongoing incidents to the media on the telephone, which was live telecast nationally. The joint director in siege talking to journalists on phone and the media telecasting it. Narrated the ongoing incidents to the media on the telephone. I state and submit that my conversion with the social media personnel was purportedly telecast on national television. I confirmed the said fact after the incident was over. I state that it was only around 9 p.m., that is after the telephone call had been telecast nationally and the CRPF had reached the Nizam Palace complex, that the police personnel of Kolkata police withdrew from the blatant siege of my house. My lord, when your lordships are on this, please also see the affidavit, my lord, of the person who went for interrogation, my lord, that is Mr. Tathagat Vardhan, DYSP, which is at page 90.
Now, what happened after this? This affidavit was filed in that.
In some other proceedings, my lord.
What happened?
We wanted, my lord, the interrogation of the then police commissioner who became DG now, and now he is a member of parliament. We were permitted, my lord, to have his interrogation, but still, my lord, the whatever, my lord, what destruction had happened. Now, my lord,
this reputation was also under 32.
No, this was a petition filed by somebody wherein we were directed to investigate. We were respondents. We were directed to investigate. So we were directed, and therefore we were carrying out the directions of the court.
This was in some contempt petition.
Yes. So we filed a contempt petition. I'm just pointing this out that these are contemporaneous facts. And my lord, I'm not reading, my lord, but this police.
This incident is contemporaneous or
no, 2 years.
2019.
2019.
19.
My lord, the visuals are.
Stating submitted on
second paragraph.
Yes.
Lord, visuals are shocking and embarrassing as citizens. When the Honorable Chief Minister thereafter sat on a dharna, the uniformed police officer sat with her on dharna. IPS officials. Lord, I have got the photograph. I leave it for your lordship's consideration. I don't want to, my lord, sensationalize. The photographs are on record, but they are black and white. My lord, I have procured, my lord, the colored photograph. Kindly, my lord, see at your lordship's leisure. This was the position. And my lord, it was being live telecast. I have heard it. That joint director is asking for help and nobody is going there. Ultimately, my lord, the Home Secretary had to send, my lord, the Central Police Force to rescue the family.
This was the 2019 incident.
Yes. My lord, then there is another incident. Please come to page 20. Another incident.
Yes. Page?
Page 20
of the writ petition.
Yes, yes. Para Roman 8, writ petition.
Yes.
In yet another case, another case, not the this case which I narrated. Yet another case of hearing of a bail petition of a sitting minister, Your Lordship gets it.
Yes.
In the cabinet of the Honorable Chief Minister, who was guilty of serious offences being investigated by the CBI under the orders of this court, the sitting CM with a crowd, it should be sitting law minister. It's a mistake. I appeared, I am aware. Kindly allow me to correct. It's not. CM went to the office. Law minister came to the court. Court, not only court room where the hearing was going on. Law minister with a crowd of about 5,000 people entered the court premises. The sitting chief minister and the crowd remained in the courtroom, again law minister, itself creating an intimidating atmosphere for the judge to decide impartially. These facts are also brought to the notice of Calcutta High Court, but nothing has happened so far.
But the law minister was there to maintain law and order.
My lord, their stand is here, my lord, when we asked that when the chief minister barged in the present case, what was DG and police commissioner doing? Their answer on affidavit is that she is a Z category protectee. So we were there to give her protection, as if the Director General of Police is a personal PSO of the chief minister and he is not supposed to do any policing work and be with the chief minister. I'll come to that. Then, my lord, Roman 10. Such FIRs have manifold ulterior motives. The first is to intimidate the officers, to deter them from conducting any investigation in the present or in future. In the instant case, under the guise of FIR, please note this, in the instant case, now I'm coming back to the instant case, West Bengal police took away CCTV camera which has captured the unlawful activities of Honorable Chief Minister. When she entered, with whom she entered, how many police force was there? There were CCTV cameras, my lord. But they said they have registered cases against me, and as a part of that investigation, they removed the CCTV cameras and took it as, my lord, case custody. This is also an offence of destroying the evidence under the garb of investigation. Now, your lordships may kindly come to Lord para 21, page 21, para 21. Lord, kindly come to 23 instead. And when your lordships are examining whether to exercise or permit me to invoke the fundamental right under 30, 32 itself is a fundamental. So your lordships would also examine at whose behest, Lord, the PMLA authorities are acting. Lord, I'll come to that, Lord. Please come to page 23. This is the ground I have given for asserting, my lord, that I have a right. The officers of the ED and ED as an institution to protect its own security and security of police officers in a representative capacity can come before your lordship. Para page 23, para Roman 2. To protect the fundamental rights of victims of a large-scale economic offense of money laundering arising out of systematic illegal mining in the state of West Bengal, wherein the proceeds of crime amounting to a staggering rupees 2,742 crores generated from plundering of natural resources and public revenues, and the offense requires a free and fair investigation, which is a facet of Article 14 and 21. ED is acting as parent patriarch, is also filing this petition as a guardian and rights and interest of citizens who are unable to protect themselves, particularly in case of this nature involving large-scale economic fraud, loss to public exchequer, exploitation of natural resources, and where the victims are diffused, unorganized, and unidentified, being citizens of India, who are the ultimate owners of the natural resources of the country in view of public trust doctrine. The ED seeks enforcement of positive obligations upon the state to protect the fundamental rights of citizens from systematic economic crimes being committed with the shelter of highest functionaries of the state of West Bengal. And instead of providing assistance to the ED to unearth the crime, the sitting chief minister in the present case have actively caused obstruction of investigation by barging into the search premises, etc. Then K, the next page. Because when the political executive uses state machinery to obstruct investigation, the rule of law ceases to operate, warranting immediate interference by constitutional courts. And I will show the judgments. Rule of law is a part, parcel, and heart of Article 14. Now, my lord, kindly see, my lord, what we do as, my lord, enforcement directorate. What is enforcement directorate? Take FEMA, my lord, for example. Lord, this is where, my lord, my existence stems from. And ultimately, my lord, what is the purpose of ED? I will show. The purpose of ED, we act on behalf of the victims of laundering. And we return the money. My lord, that's where my argument is going to be. My lord, please have a look at section 36, my lord, of FEMA.
Section
36 of Foreign Exchange Management Act. ED is constituted under this. It is not my case that ED is an independent department or it is a juristic person, etc. That's not, I'm not putting it that way. They created a ghost, and in all the arguments they tried to kill that ghost. That's not my case at all. The central government shall establish a directorate of enforcement with a director and such other officers or class of officers as it thinks fit, who shall be called officers of enforcement for the purpose of this act. Without prejudice, your lordships are not concerned with the rest. This is where the ED comes into the picture. Now, only for one section, please have, my lord, PMLA. What is PMLA and what are we doing? Lord, whenever we find what is known under the PMLA parlance as proceeds of crime. Lord, one, there has to be a crime. Crime in the present case is illegal excavation of coal from the government refinery. Coal is a natural resource and that is being sold, and the money generated is transferred to various persons through Hawala transaction. That's the crime. The proceeds of crime would be obviously, my lord, in terms of money. Lord, that money, when we recover, what we do? Lord, please come to section 8. And I represent these people. Section 8, subsection 8. Lord, we take the matter to the trial court. Lord, there is a first attachment. Your lordships need not go in detail into that. But once, my lord, proceeds of crime are found, there is an attachment. Attachment results into, after procedure, my lord, followed, confiscation. Thereafter, matter goes before the competent court. But what happens to the money, my lord, which we recovered is 8. Where a property stands confiscated to the central government under subsection 5. I'm sorry, my lord, this is Anjari. Section 8, subsection. Lord, we attach the property, attach the money or property if it is converted, then it is confiscated to the central government. And thereafter, what happens, my lord, to that money? Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered quantifiable loss as a result of offense of money laundering.
Who are those in this case?
That the court will decide.
No,
The court will
it is
decide.
yet to be confiscated.
No.
It is yet to be confiscated.
I'm on a slightly different point.
Yes.
But for example, in a banking fraud, we have, the ED has under section 8(8) distributed to the identifiable victims 37,000 crores. 37,000 crores are given back under 8(8) as identified by the competent court to the victims of the crime. When I am prevented from exercising my duty or exercising my power, the affected party is the victim. I am also, my lord, invoking your lordship's 32 on their behalf.
Who is the victim in this case?
Lord, that belongs to the people. Lord, that the court will have to decide.
It belongs to the Coal India Limited.
Yes. It would be
Coal India Limited itself is not a natural person.
It would be, my lord, I'm not on that.
You
I'm
see,
on
in a given case where the victims are public at large, money has been collected from public and that is siphoned and some XYZ.
Yes.
So the ultimate victim is the public at large. But in this case, the victim is the Coal India Limited.
Maybe the nation at large.
The subsidiary. So nation is also not a natural person.
I'm not colored on that.
Yes.
I'm saying that ultimately your lordships are protecting the victim of crime. Even if, my lord, we cannot identify the victim of crime, it will go in, my lord, the consolidated fund of India and will be used for the citizens of India. So this is not a case where the ED officials, my lord, per se, but before your lordship,
But in that sense, every government organization, statutory body is established and is working to protect the rule of law. So then everybody can maintain a Article 32 petition.
No,
I am there for the citizen of India. Every law is made for the benefit
your
of
lordships are right.
citizen of
That
India.
is one view. That is one view. I'm my lord, perfectly, my lord, in sync with what your lordships are respectfully. But I'm respectfully in view, my lord, with what your lordships are saying. But here, Lord, I am the officer of the ED. We are the officers of the ED. We are harassed. We are facing criminal investigation. And now please come to, my lord, page 29. Look, these are the 4 FIRs registered against us. By whom? By West Bengal Police. West Bengal Police is under the Honorable Chief Minister, under the Director General of Police, under the Police Commissioner, all of whom are, as I have already shown, are part of the offense of destruction of evidence, trespass, illegal trespass, not permitting official discharge of duties, etc. Now, so those people have filed case against me, and I'll show, my lord, what is my prayer. Now, my lord, also see ground